Federal law does give you some rights. There's a federal consumer protection law called the Fair Credit Reporting Act. Ignore the word credit in Fair Credit Reporting Act. It really should be called the Fair Consumer Reporting Act because it covers much, much more than just credit. But it is the federal law that governs what I, as a background screening company, what employers who are using our reports can and can't do. First thing you need to know is that under the FCRA, most negative items disappear after 7 years. This is the law that makes stuff go off your credit report after 7 years generally. However, if you're applying for a position where you're reasonably expected to make more than $75,000 a year, those limits don't apply. And so why $75,000? That's not that much money. Well, it was in 1971 when the law was passed, right? And this is, you know, they keep adding stuff to the law, but they've never changed that number. So now that $75,000 number doesn't seem that high. The one item that doesn't ever go away under federal law are criminal records. Criminal convictions do not go away. Dismissed cases are reportable for 7 years only. Deferred adjudication, cases that were dismissed are only good for 7 years, but convictions stay forever. Now there are states that limit the reporting of convictions, including California, and they're only good for, in California you can only report, I can only tell an employer in California about a conviction for 7 years. So sometimes I'm talking to a job seeker group. I also work with reintegration groups that help former offenders find meaningful work. And somebody will come up to me and say, my offense is 10 years old and nobody will still hire me. And they tell me what the offense is and it, creeps me out. And then we'll talk about it and I'll tell them, you might want to move to, California. As a Texas taxpayer, you really might, let me suggest that you want to move to California and do your next offense there. But some of these offenses, they go away in California after 7 years. Another requirement of the Fair Credit Reporting Act, the federal law, is that the employer must disclose to you on a separate document used exclusively for that purpose that they're going to procure a background check, a consumer report. And it's got to be a separate document. You've probably all seen those in the application process. It's separate from the employment application. That disclosure can only have information in it about the background screening process. Then you also have to give them a signed authorization, and it can also be an electronic authorization, like an e-signature, to procure the background check before they can ever order it. Then, once the employer gets the background check back from you, if there's anything in the report that may, and that's the operative word, anything that may adversely impact the hiring decision from your perspective, this is a consumer reporting law, so from the perspective of the consumer, of the job seeker, the applicant, or the employee, if there's anything that may adversely impact that decision, then before they make the decision, they have to give you a copy of the report and a copy of your rights under the law. That's the federal law. Before they make the decision, you should get that. And most employers are aware of this, especially your larger employers. Now that means, though, that if an employer is just out Googling you themselves, this doesn't cover that. This only covers background checks that they purchase through a third party like me. Then you've got the right to dispute the accuracy of the information. So if there's something in the report, a former employer says you were terminated involuntarily, and you know that's not accurate, you can dispute that back to the background screening company and say that's just not right. And they have 30 days, the background screening company has 30 days to reinvestigate that. A good background screening company, to be honest, will get it done that day or the next as quickly as possible, because we don't want our clients to lose a good candidate because of an error in another employer's records or anything like that. So we'll immediately follow up with that other employer. Often what happens in those cases, especially when it's former employers, is that the applicant has already called and negotiated something with that employer now is not going to give that information. So we'll call to verify, and the employer says, oh, well, we don't provide that information. Okay, well, then we go back to our client with a different report, an altered report to change that. And then once the employer's made the hiring decision, they have to give you another notice of, that based in whole or part on this background check, we are making this hiring decision. And it may not be that they're not hiring you. For instance, one of our clients is an ambulance company, ambulance service provider, and they pay their employees based on how long they've been in certain roles with previous EMS providers. So somebody's, their application I think just talks about the last job. So somebody was with another EMS service for a year or 2 years, let's say, but it turns out when we do the verification, they were actually only riding an ambulance for 6 months. So that's going to affect the pay of this applicant. And so in that process, if the background check comes back and it affects the pay, this whole process should kick in and they should get that notice. So it's not just you don't get hired, it's if they consider you for a different position or pay you differently, anything like that that may, from your point of view, be considered an adverse action.